Welcome back. A teen who faced a felony charge over a classroom joke is filing a lawsuit against his former school. Jackson Leggett filed a lawsuit against his school in Newark, Illinois, claiming a sarcastic joke following senior pranks turned his life upside down. Leggett made the comment when the school stated they were allowed to prank teachers as long as no damage was done.
Leggett made the comment, "What do you think I'm going to do? Burn the school down?" He was later arrested and charged with felony disorderly conduct, spent 8 days inside a juvenile detention facility. He's now calling for compensation for the danger that he was put in while he was inside that facility and the time he missed out on while out of school.
All right, so joining us now is our chief legal analyst, Khalif Rhodes. When you look at this suit against a whole school district and specific leaders, do you think that this will hold up? Does this case have legs to stand on?
There are legs, but it's complicated. I mean, this is not as straightforward, like, oh, you can run right to the courthouse and get some magical payday. There are a lot of hurdles to jump over because it's convoluted. I mean, if we're looking at the speech aspect of it first, the courts have held a number of times that speech is extremely protected. School speech can be limited. The government can chill your speech as a student, but you don't lose your ability to have First Amendment rights just because you walk through the courthouse. That was from one famous judge that mentioned this, that students have the same rights as us. The school can protect other students from the harassment, from other things like that. I don't think this rose to that level. I don't even think this is communicating a threat. I mean, he asked a question and then posed it in a way sarcastically where everyone understood that there was a joke. They charged him with some felony disorderly conduct, but you'd have to have caused some disorder. And so there are no facts to support. He made a statement, and then it was mass hysteria. People were running around, running for shelter. If the facts were of like that nature, then I think it would have supported a charge. So because I don't think there's a charge, you got a couple things. Is it retaliation for First Amendment? Is it some type of other, malicious prosecution? Either one of those are going to be hard for him to prove, but also those are going to probably be his easiest way to having some type of possible outcome in this that is favorable towards him.
Part of Leggett's claim is that school officials and law enforcement, they took what I guess he thought should just be a simple disciplinary action, raised it quickly to criminal charges. When it comes to police, like what standards do they look at, especially when you're dealing with a minor, when it leads to an arrest? Well,
the standard is still the same. It's probable cause. Do I have probable cause to make an arrest? And the standard for that is it more likely than not that a crime has occurred, and is it more likely than not that you have committed this crime? And that's why I go back to the original statement. I don't even think there was a crime committed here. So then it can't be more likely than not that he committed the crime, because there wasn't a crime. And so even the officer said, I didn't think there was anything criminal about this. The deputy said in one of the statements, but yet they somehow still arrest him off his lawnmower, as the kid described. You talked about some of the things he missed prom, missed basketball games, missed opportunity to be a student in the senior year. You can't get that back. So that strengthens his case when you talk about people that are sitting in some potential jury wanting to say, hey, did we rob this kid of something that now we can monetarily compensate him for? Potentially.
Khalif, it makes me wonder how this even got this far. I mean, at some point there should have been a check, right? And then for the juvenile detention center, even if the teacher, the school district says we want to suspend you, even though the sheriff's department said they went through everything, why would they go forward with the arrest?
What I can say is we're in a heightened era of rush to judgment in a number of places. Obviously, we've shifted through the Me Too, and where a number of individuals were canceled instantly. And in that era, a number of things changed, specifically instances where you're making potential threats, where folks are going to, even if it's a joke, are going to take it like it's a serious matter. And this is a situation that I think there were really no adults in the room. Even though this is a juvenile situation, you have adults that are saying, wait, this is a kid. Typically, you'd allow this to be handled inside the school. There was no harm at all, not just like, okay, a light, some type of assault or some type of fight, but there was not even an allegation of a true threat. So I don't know how we got here. And so I hate to give your answer with the I don't know, but that's the only process that I can see from this is I don't know how we got here. And that's why his attorneys are saying there needs to be something after that. And after that typically is litigation. So how do you compensate a person to make them whole for missing things that you can't compensate for? I don't know, because I don't know how you put a dollar amount on missing your senior year, but I suspect his attorney will attempt to figure that out.
Yeah, and also he's saying for the time he spent in the juvenile detention facility, which probably was
8 days, you said.
Yeah, it's a long
days.
time and maybe not the safest feeling place. So definitely interesting, and we'll follow this one to see what comes. Thanks, Khalif.
Queen City News Plus. Just search Queen City News on your smart TV's app store.